Okay, we'll move on now to our next case, Central Florida Regional Hospital versus the Agency for Healthcare Administration.
May it please the Court, my name is Stephen Asenia. With me at council table is Rick Ellis, and together we represent Central Florida Regional Medical Center, Inc. The question to be answered by, and Your Honor, I would like to reserve 4 minutes for rebuttal. The question to be answered by the Court in this case is whether a CON applicant can partner or joint venture its application with another entity, yet fail to disclose the details of that partnership to the agency in its application. The specific issues in this appeal are whether the entity that filed and received approval from the Agency for Healthcare Administration for a new hospital in Seminole County, Oviedo HMA, is in fact the CON applicant. Central Florida Regional submits that the applicant in this case is actually a partnership between Oviedo HMA and Orlando Regional Medical Center or Orlando Regional Health System, and that Oviedo CON should be withdrawn from further consideration because it is no longer the applicant, and required financial schedules don't contain essential financial information about the partnership. The second issue...
Counsel, let me stop you just for a second. I have read your exceptions to the recommended order here, and I don't see where you argued explicitly there that the recommended approval of Oviedo's CON application is erroneous because the applicant changed. Could you point to me where you explicitly raised that?
We did in the exceptions. There is a paragraph in the exceptions, Your Honor, and I can cite them for you when I come back. I don't have the exceptions with me. There is a paragraph in the exception where we talk about the applicant changing and address that in the exceptions specifically. And I can give you the page when I come back. I don't have that before me. But we did raise the issue in our exceptions with respect to the applicant changing. That has been addressed. The second issue, Your Honor, is whether the agency erred in concluding that Oviedo HMA's proposed hospital would better enhance access to hospital services for residents of Seminole County, and therefore is more deserving of approval than Central Florida Regionals. We submit that the entire basis for the determination that their application better enhances access is the collaboration with ORHS, the details of which were not provided in the application and which, if permitted to stand, creates a fundamentally flawed and patently unfair process. Seminole County, Florida, is currently served by 3 hospital systems: Central Florida Regional, which is situated in Sanford; Florida Hospital Altamont, which is owned and operated by the Adventist Health System, which owns and operates 7 hospitals in the greater Orlando area; and South Seminole Hospital, which is owned and operated by Orlando Regional Health System, which owns and operates 5 different hospitals in the greater Orlando area. Together, Florida Hospital and ORHS dominate the market for healthcare services in Seminole County to the virtual exclusion of Central Florida. In 2001, both Florida Hospital and ORHS filed applications to establish a new hospital in Oviedo. Florida Hospital was approved, but decided to abandon the CON. In August of 2004, Central Florida, Oviedo HMA, and ORHS each filed letters of intent with AHCA to file a certificate of need application for a new hospital in Oviedo. At the time, Oviedo HMA was a newly formed entity, effectively a shell corporation and a subsidiary of HCA, which was incorporated for the purpose of HMA, which was incorporated for the purpose of constructing, owning, and operating the proposed hospital. The filing of ORHS's letter of intent was actually a strategic attempt to position itself to participate in the development of a new hospital. Due to pressing capital needs in its downtown campus facilities, ORHS did not want to pursue a hospital in Oviedo on its own and incur the significant costs involved. ORHS made an exploratory call to Central Florida concerning a possible affiliation. Central Florida wasn't interested, and then ORHS moved on to HMA. On the date the omissions for the applications were due, HMA and ORHS entered into a letter of intent to develop a definitive agreement for the joint operation of the Oviedo Hospital. The letter of intent includes non-compete provisions upon which ORHS agrees not to pursue its own application and to support the Oviedo HMA application. Accordingly, ORHS did not file an omissions response, nor did it disclose its ownership interest in the Oviedo HMA application. Significantly, the Oviedo HMA application makes no mention of the financial and operational arrangements with respect to the joint venture. In talking about the collaboration with ORHS, the only mention was with respect to contracting with hospital-based physician groups that ORHS currently maintain, that they would use the same emergency room physicians, anesthesiologists, radiologists, and pathologists. No ownership disclosure at all. No mention is made of the fact that the deal that they had verbally agreed to would be that ORHS would contribute 20% of the capital cost for the project. They would in turn receive 20% of the profits and bear 20% of the losses if losses were incurred. The verbal agreement between the parties, pursuant to the testimony of Carl Hodges, ORHS's Director of Development, was considered a done deal, and effectively a verbal contract was entered into between the parties. At the hearing, it was established that the collaboration between Oviedo HMA and ORHS is a specific and codependent business arrangement as opposed to the use of common physician groups. The administrative law judge found that Oviedo HMA's proposal does not enjoy the unconditional support of its parent organization. Rather, the proposal was contingent upon a collaborative effort between the two parties. HMA, another significant point here.
But didn't the hearing officer also find that the structure doesn't affect the corporate status of Oviedo HMA?
Well, the judge failed to rule on the specific issue of whether the applicant had actually changed. The judge found that the applicant did remain the same. The applicant is Oviedo HMA Inc. And what we've got here is a situation where form is being put above substance. We have a partnership between the parties. The parties have met all the elements of a partnership.
But as I understand it, the administrative law judge found that there was a proposed stock purchase, not a partnership.
Well, it is a stock purchase. They were going to purchase the stock, but all of the elements of a partnership, he also found specifically that all the elements of the partnership were in effect. The elements are, it's an association to carry on the business of the proposed hospital as co-owners for profit. There's the requisite mutuality of interest in profits and losses. There's an oral agreement. And this is a general partnership, which is an entity unto itself. If this were simply a stock purchase agreement, we wouldn't be here before you. Because a stock purchase agreement, you buy stock in a company, the operator of the company moves forward and does whatever they want, and you receive dividends based on your investment. This is an active participation in ownership and operation between ORHS and HMA. If there's a loss here, ORHS suffers the loss. There's capital contribution requirements with respect to the capital, 20% of the capital for the project. And more significantly, none of this information was put before the agency in terms of the application that was reviewed. I mean, the fact that this was a deal that was struck at the time the omissions that was being negotiated after the letter of intent was filed, and it was struck on the date the omissions were filed. This is clearly a partnership arrangement between the parties, even though it's in the guise of a corporate structure. I mean, as the Donahue case demonstrates, under Florida law, a joint venture or partnership relationship exists regardless of whether the joint ventures or partners carry out the purpose of their agreement through the medium of a corporation. And that's what we have here. I mean, I don't dispute the fact that there was a stock purchase, but there was much more to this deal than a stock purchase. Neither of these parties would have moved forward absent the other. HMA's witnesses, and they've cited a number of examples of testimony from their own corporate witnesses. HMA said we would not be in this market unless we were in a collaborative venture between HMA and either Florida Hospital or ORHS, because they're so entrenched in this market that we don't think we can make a go of it without the other party. So clearly there is a codependent relationship here between both HMA and ORHS, and neither party would have gone forward without the other.
But isn't there, the question that I have, it seems to me our standard of review is whether there's competent substantial evidence to support particular findings. And the finding here that the persuasive evidence indicates that Oviedo HMA Inc. will own and operate the new hospital, finding 15, seems to me there's CSE to support that. Why isn't there?
I think it's an error of law. I think it's an error of law. I think as a matter of fact, there was a demonstration in this case that there was, in fact, a partnership, and the elements of a partnership were acknowledged. There was this contribution of capital that ORHS is making to the deal, the codependent relationship between the parties. The fact that the corporate entity, Oviedo HMA Inc., is going to actually receive the license, I think that's where the error is. That is a question of law. And the fact that there was the elements of a partnership, demonstrated in the course of the hearing, I think, and those elements were found by the judge. The judge never ruled on the issue of whether there was a change in applicant. In our exceptions, we pointed out that the ALJ left open the question of whether the applicant had changed in violation of 59C 1.008. That's the rule that says an applicant can't change. And the failure to disclose the specific terms of the Oviedo HMA partnership in the comparative review process. In its final order, ACCA never ruled on that. And I think that the question is open. I don't think the judge did make a finding that Oviedo HMA Inc. would be the applicant, would be the entity that receives the license, and we don't dispute that. But the truth of the matter is this deal is so much different from a deal that would have been put forward if it was just HMA.
Is it your contention that if there's a corporate applicant and 30% of the stock ownership in that applicant, control of that applicant, changes during the process, that you have, in effect, a different applicant?
Not if it were simply a mere stock purchase. But the facts of this case demonstrate that we have more than that. I think that if an entity came in and bought, if ORHS was a passive investor, if ORHS said, we're going to buy 30% of this corporation, that's it. I don't think there would have been a change in applicant. But we have more than that here. What's going to happen? The whole collaboration here rests on the fact that these two parties are going to work together. The evidence demonstrated in this case that ORHS has been in several partnerships that have all unwound. What happens if this partnership unwinds? Are all the benefits that the judge found that are going to flow from the collaboration going to then go away? And those are the kinds of things that we believe needed to be before the agency. None of that was done. This was a deal that was hatched as the CON process was unfolding. In hearing, bits and pieces of that came out, but the whole deal didn't come out. And I think that the CON process is designed to ensure that in a comparative review, the parties have an opportunity to review and understand what the deal is before the agency. All the financial schedules are wrong. The financial schedules show that HMA is going to rely on its parent company for 100% of the financing. Pursuant to the joint venture that's been struck, 20% of that financing is now going to come from ORHS. 20% of the profits, the balance sheet is going to look different because 20% of the profits and losses are going to be distributed to ORHS. And that's the difference, Judge, between the position that or the example that you're posing where you have a corporate applicant and somebody simply buys stock, and between an active partnership, which is what we have here. And I think that the elements of the partnership were proven, and the judge failed to rule on that on the final, in the recommended order, and the agency failed to take note of it in the exceptions. With respect to the second issue, it's our position that this whole issue of the determination that access would be enhanced by approval of the HMA application is wholly contingent upon the collaboration with ORHS. And but for that collaboration, this issue would have been determined in Central Florida's favor.
It seems to me that didn't the ALJ weigh the various factors in favor of Central Florida in some instances?
He did, and he found, and in fact, there's a finding in the recommended order that if the reviewing court or the agency found there to be a change in applicant, that ORHS, that the Central Florida regional application should be approved. And in fact, with respect to access, there's really two issues with regard to access. The first is geographic access. And with regard to geographic access, what we have here is a situation where patients, the reason he gave the nod with regard to access to HMA was because HMA had a collaboration and agreement to send tertiary patients that needed advanced care to the downtown campus. Those people are actually leaving Seminole County to go to Orange County for services. Our proposal, where we had a site, they don't have a site, we have a specific site in the city of Oviedo, is going to afford access to residents of Seminole County because the hospital is already going to be in Seminole County. Those people are not going to be shipped out of Seminole County. The other access issue is economic access.
But
And the judge found
aren't
that.
you asking us to reweigh the evidence here? It seems to me that's not our job.
On this issue, Your Honor, I think that the issue of the collaboration between ORHS and HMA flows into the issue of access, and we believe it should be reversed.
Mr. Senior, you've used all of your time, but we'll reserve about a minute and a half for you.
Thank you, Your Honor.
Yes, sir. We'll add a minute and a half over on the other side as well.
Thank you, Your Honor. My name is Susan Smith with Smith & Associates. I'm representing Oviedo HMA, Inc. We're here today to discuss two CON applications to provide a 60-bed hospital in Oviedo. As the ALJ found, there are many similarities between these two applications, but there's one big difference. That is, when a patient presents in Oviedo that's too complex to be handled there, where's that patient going to go? Central Florida's proposal is to send that patient to a 226-bed hospital in Sanford. Oviedo HMA's proposal is to send that patient to a world-class tertiary center run by ORHS, which includes MD Anderson Cancer Center, Arnold Palmer Children's Hospital, Winnie Palmer Hospital for Children and Babies, the only level 1 trauma center in the area, the only perinatal intensive care RIPIC center in the area, a world-class open heart surgery provider. On and on and on, the evidence was presented at trial that this
Counsel, how many physicians did ORHS have practicing in the Oviedo area?
ORHS had at least 40, potentially 60 physicians on its staff that had offices with patients that they were treating from the Oviedo area. And we had a number of those physicians that testified that said, but for a close working relationship with ORHS, they would not have privileges or work at this new hospital because they didn't want to go take call coverage at Sanford if their patients got sent down there, or because they had had bad experiences with Sanford, or because they believed it was in their patient's best interest to go to a tertiary provider instead of being sent to a community hospital in Sanford. And that's what the judge found in this case. He said, I looked at all the evidence, I weighed it, I balanced it, all the things they're asking you in point 2 to look at is exactly that. The judge gave him credit for the land, for having a purchase site. The judge gave him credit for increased competition. He gave them all the due credit and then some, and said at the end of the day, this comes down to quality of care for patients, and I'm not going to award it to a less worthy applicant when I can see that patients are going to be better served by having this collaborative agreement. And I just want to go back to one thing that Mr. Acina said. He said that this whole issue of the collaboration was not discussed. It's true, the 20% stock purchase was not discussed in the CON application, but the collaboration was discussed throughout the CON application. And I'm just going to briefly read to you from page 1. On the first page of our CON application, it says, Orlando Regional Healthcare System, ORHS, has decided not to file in the admissions period, but rather strongly support HMA's application and work collaboratively to integrate ORHS's and HMA's combined strengths and services in Oviedo HMA Hospital. And that was stated throughout the application in numerous letters of support and by numerous witnesses. So I think you were exactly right, Judge Van Noordhoek, when you said look at finding of fact 15, but also if you look at finding of fact 120 in the recommended order, the ALJ says, Oviedo HMA will also operate the proposed hospital notwithstanding the intended collaboration with ORHS. And that's a very important finding of fact. This is a factual question. All of the issues that they brought up here today about who's really going to be the owner and operator were tested at trial, and the judge found, as a matter of fact, I believe that Oviedo HMA Inc. is going to be the owner-operator. As to the Donahue case cited by appellants, it does not stand for a proposition that any stock purchase magically transforms the purchaser and seller into partners. And here's why. They kept saying over and over, all of the elements are present, but there's not. There's one key element that's missing. That's mutuality of control. It's black-letter Florida law that a partnership requires mutuality of control, and that is absent in the facts of this case as the judge found them. He found that the owner-operator will be Oviedo HMA Inc. not some alleged partnership, not ORHS, Oviedo HMA Inc. And if there's any competent, substantial evidence in the record to support that finding, then you're bound to that finding. And I submit to you, there's not only some competent, substantial evidence, the record is absolutely jam-packed full of evidence that the intended owner-operator of this hospital is going to be Oviedo HMA Inc.
Counsel, under the control theory, would it make any difference that ORHS was to receive 20% of the profit and share accordingly in the losses as well?
I think the theory that they're going under is to say somehow that's an impermissible amendment, and that's what Mr. Acina was talking about. All the schedules and financial documents would be changed. And I'll tell you, as a matter of first course, I believe that is the argument that was procedurally waived. Nowhere in the exceptions is the word impermissible amendment ever stated. Nowhere is that particular rule, which is a separate and distinct rule from change of the applicant entity, ever cited. And there's a plethora of cases out there about impermissible amendment, none of which were cited. So that's where that issue comes in, is the 20%.
Let's assume for the sake of argument this issue was not waived, and how would you respond to that?
Sure, absolutely. I do not think this creates an impermissible amendment, and here's why. The impermissible amendment standard is, does the alleged infraction change the nature or scope of the proposed project, or does it come within something that was raised within the CON application? And I'll give you an example of something that was found not to be an impermissible amendment and something that was found to be an impermissible amendment, so you can get the distinction. In the NME case, which I think is kind of a seminal case cited by both parties, there was an applicant for CON for a NICU, a neonatal intensive care unit. And in that applicant's CON application, it said NICU ambulances are available 24/7 within 30 minutes time. And then at trial, they wanted to produce a doctor who was saying something contrary to that the ambulance wasn't available, and that was a reason why they needed the services. The judge allowed the testimony, but made a specific finding of fact that the statement contained in the CON application and the statement offered at trial were inconsistent. When that recommended order recommending approval of a NICU was sent to ACA, the opponent raised the impermissible amendment rule where you're supposed to raise it, and ACA said, no, it's still a project for NICU services. It's still a neonatal intensive care case. The nature and scope hasn't been changed, and the concept of emergency service was raised within the CON application, so it's touched upon. I don't care that it's inconsistent. So what that tells us is that the threshold for an impermissible amendment to overcome that challenge is very low. Now, if you'd like, I'll give you an example of a case cited by appellants where they did find an impermissible amendment, and I'll tell you why that's factually distinguishable. That's the Brookwood case. That was a nursing home case. And in that case, the applicant was applying for a nursing home. They told ACA about a one-story building. During the course of discovery and at trial, it turned out the building was a two-story building. The nursing home was on top, and on the bottom was a proposed assisted living facility that was also going to be run by the same applicant. And in fact, the applicant wanted to rely upon referrals from the ALF on the first floor to send them referrals to justify their numbers for the second floor. The construction costs were doubled, the square footage was doubled, and ACA said, that changes the nature and scope. That's an impermissible amendment. And the applicant said, no, it's not. It's a different project. It's something totally different. We were only applying for a nursing home. And ACA said, no, you're actually applying for a combined nursing home ALF. And by the way, even if you were only applying for a nursing home, as the applicant entity, you had a duty to list that ALF in your Schedule 2. Which kind of brings me to, and I'll just say, that's the kind of thing that turns out to be an impermissible amendment when you're drastically changing the scope and breadth of a project. But that takes us to another red herring issue, which is they say that all the financial schedules and all the evils to be done because so much information wasn't presented to ACA. And I'll tell you that all of the CON applications rely upon the applicant entity. So unless you buy into the fact that a partnership is suddenly created by the stock purchase, unless you accept that, then none of the financial schedules change because the financial schedules relate to the applicant entity, Oviedo HMA Inc. And without changing that, they don't change. But
do the financials, in effect, represent that the capital will come from the parent corporation of Oviedo?
There is a representation in the application that HMA will be funding this project, But that's not a required item in a CON application. That's just something extra that they put in. There's actually case law, a recent Promise case that I could probably find the site for you but there's a plethora of CON law out there that states that you do not have to include the audited financial information of a parent, a subsidiary, a partial. It's only the applicant entity that you have to include that information for, and that information was included in the CON application. And the Promise case, which came out in 2007, is exactly on point with that, and in fact, it was a startup corporation, and they had no audited financials in there, and the ALJ still found, you proved it up at trial that you can fund this. And just one more brief point on that. If you look at finding of fact 16, the judge specifically found that ORHS has sufficient funds and is committed to expend them, and that's also found as specific finding of facts related to Oviedo HMA, that it was stipulated that they have the funds. And in truth, there's no question that both of these entities have ample funds to fund this project. And in fact, there was a stipulation before trial that funding wasn't even at issue. So, I think that issue's been waived, certainly by the stipulation. It was found by the judge. It wasn't raised in exceptions. And there's really no contested issue that they have the ability and commitment to fund it. And that's the only place where the proposed stock purchase could have any kind of ramification at all. And that finding in finding of fact 16 answers that question. There was some argument that that because the collaborative agreement had not entered into a definitive agreement, that somehow all the benefits were speculative and that there couldn't be any weight given to that. And I want to address that just briefly, because there was definitively a factual finding by the judge that this is an agreement that the parties are going to enter into. And that was at finding of fact 12, where the ALJ concluded that HMA would not pursue the project without the collaborative, clinical, and financial agreement with ORHS. And so he goes on under the assumption that they're going to pursue this, because otherwise they wouldn't. There was a ton of evidence on this factual question. You had a letter of intent signed by both parties that was admitted into evidence that said, we intend to go forward with an agreement. You had testimony of senior officials, including the CEO of Orlando Regional Healthcare System, the chief development officer of that system, senior executive vice presidents of HMA, the chief financial officer of HMA, and they all testified across the board that the parties intend to go forward with this collaborative agreement. So I think as a matter of fact, there is no question as to whether or not the benefits of this agreement can be considered and realized. It's no different than what comes up all the time in these CON cases, because they're sort of perspective in nature. So you have an open heart surgeon, for example, who says, I'm going to be the surgeon in this program. And the hospital says, we're going to hire this person. And they rely upon the surgeon's mortality rates and quality of care to show that they're going to provide quality of care. And the opponent comes in and says, where's the definitive agreement? And they say, we haven't signed it yet. And they say, well, how much are you going to pay for it? Haven't done it yet. And they say, how are you going to possibly run this program with 5 other programs? We're going to hire another guy. Well, who's that going to be? We haven't done it yet. There's a lot of prospective things in CON applications. And the way that it works is the judge looks at all the facts surrounding it and decides, do I think this is kind of a pie in the sky that maybe this surgeon's going to be the surgeon, or maybe there's going to be a collaborative agreement? Or do I believe, as a matter of fact, that this is something that's likely to happen and that's going to happen in the future? And that's what was determined here, is the judge believed that both of these parties were committed to go forward and work in collaboration. And I'll just say one other fact, that the collaborative agreements that are discussed by the applicants are not, in fact, contingent upon the stock purchase. There's a referral relationship that could exist between these entities absent any stock shares traded at all. I joke, I said there's all levels of relationships. You could be dating, you could be married, and there's several steps along the way. And, yes, the stock purchase would be an equity share, and that would be even more commitment, but there's a lot of levels of commitment discussed by a number of physicians that include collaboration, and I'll give you one small example. The emergency physician group that represents the Orlando Regional Healthcare System testified via deposition that they would not enter into a contract to take emergency call services at the Oviedo Hospital unless it had some type of affiliation with ORHS. And yet, at the time of the final hearing, they had signed a contract with HMA. And that type of evidence is the facts and the meat that was put on these bones to say, is this something that's really going to happen? You have to look at the number of physicians that came forward that are on staff at ORHS and said, yes, I want to work for this hospital. I think Oviedo is a great area, but I'm only going to do it if you're affiliated with ORHS, and that's what I understand Oviedo HMA Inc.'s plan to be. And so it was very clear to the judge after 3 weeks of trial that this was not some pie-in-the-sky idea thought up to, impress him at the last minute, that this was a real deal. It was discussed throughout our CON application. It was discussed, including letters of support from the CEO of Orlando Regional included in our application, including letters of support from the chief of the medical staff, including letters of support from the emergency room group, and over and over and over from the physicians that actually testified at trial that this was a real plan that was going forward for these two entities to work together. Now, because they're working together does not create a partnership agreement. I could go out and buy Coca-Cola stock today, and that doesn't give me a right to manage Coca-Cola and tell them how to run their business. And that would be true even though I routinely have contracts with Coca-Cola and buy their Coke products. I still don't have the right to tell them how to do it. And that'd be true if I was a supplier to Coca-Cola who sold them sugar for their Coke products. You have to take all of the facts together and then weigh and balance them and determine, is this a real agreement? And that's what the judge found precisely, is that there was an agreement for these parties to work together both collaboratively, and that he believed there would be a financial agreement as well. Thank you.
All right, thank you.
There's 30 seconds left.
All right.
My name is Thomas Holler, and I represent the Agency for Healthcare Administration. Given the lack of time, I'm willing to stand on the appellate briefs. If the court has any questions, I'm more than willing to answer them.
What do you exactly see the role here of as? What does that compare to Orlando Regional's role here? I mean, they're not like a vendor. I mean, that's what counsel was talking about. They're not exactly like a stockholder, because they're a little more than that, aren't they?
Well, there's a collaboration agreement.
Aren't they really more like a lender with conditions?
I don't know if I would describe it that way. Perhaps some people could.
Well, they're advancing capital.
Yes, according to the testimony, yes, they are.
And they don't get anyone on the board of directors of the corporation.
No, they don't.
But they're agreeing in exchange for, I guess, receipt of 20% of the stock to allow patients of this new hospital into their network.
There is definitely some sort of business relationship between the two entities, but it's a verbal agreement, and as I see it, it's somewhat uncertain. But that doesn't mean that there's a change in the applicant. And there is actually no precedent on change of the applicant from this court. But the way we at the agency has viewed a change in the applicant is if one entity is going to hold the license other than the entity which is the applicant. In the Galen decision, Ms. Dudek testified about how the agency viewed change in the applicant. And so although there is a relationship between the applicant in this case and Orlando Regional, I don't know if that relationship constitutes a change in the applicant. It wouldn't surprise me in this day and age that hospitals or any entity wishing to build a hospital would have a relationship with a lender, somebody funding the construction of a building like this, or have relationships with physician groups or even other third-party vendors. But I don't know how those relationships in all of those contexts would change the applicant, because we're looking at who is going to hold the licensee.
Counsel, I understand that, as you indicated, there was an agreement between the parties, but had there actually been a stock transfer or purchase at the time the recommended order was entered?
No, according to the hearing officer, the administrative law judge, there had been no stock transfer at that time, and in fact, I think in paragraphs 31, 32, and 39 of the recommended order, the administrative law judge says that the proposed sale of the stock is to occur in the future at some undetermined time.
Okay, thank you.
First, Judge Van Ortwijk, let me answer your question about the exceptions. Paragraph 8 on page 6 of our exceptions specifically raises the issue of the applicant changing and cites Rule 59C-1.008. So that wasn't specifically addressed. You know, what we're hearing here is we're hearing from the agency say, well, maybe there really wasn't an agreement and it's speculative. We're hearing from HMA that there absolutely is an agreement. The judge found HMA, the administrative law judge in paragraph 12, HMA would not pursue the project without a collaborative clinical and financial arrangement with ORHS. It's the financial arrangement. You know, the question you asked, Judge, we don't know exactly what all this means, because what they did is they dribbled out bits and pieces in the hearing and gave us information about parts of the financial arrangement. But one thing we don't know is what are the unwind provisions.
Is it your view that obviously the collaboration, the prospect of collaboration between Orlando Regional and the AMP-LE was of considerable importance to the administrative law judge? Part of that obviously had to do with quality of care issues because of the availability of the Orlando Regional facility in that network. But it also had something to do with financing too, didn't it?
Something to do with what?
With the financing, the availability
Yeah,
of this funding.
absolutely it did. And, you know, we cited in our supplemental authority the case of Florida Convalescent Centers, DBA Palm Gardens of Orlando versus Coordinated Care, Inc. and HRS. This is a DOA case that we filed as a notice of supplemental authority. And in that case, the court found that the agency found that of the 3 alternative arrangements for financing its project proposed by CCI, the first would result in an impermissible change of identity from the applicant to the license holder operator if PMV Inc. obtains an interest as a limited partner. Although CCI is the applicant, the operator would be the partnership with CCI as a general partner and PMV as a limited partner in return for a 1.4 capital contribution. In this case, the agency specifically found, on facts virtually identical to this, that change, that partnership creation would constitute a change of ownership. And that's what we have here.
But we don't have a change in the board of directors.
You know, we don't know. The question of whether they have a vote on the board of directors, that was not disclosed at the hearing. We don't know whether they would or they wouldn't. I don't know, and I think that that's part of the problem here. We have only those facts about the partnership that they chose to put forward. We have no partnership agreement. They're clearly, ORHS isn't going to pay 20% of a hospital in the $15 to $20 million range unless there's a signed agreement that specifies exactly how they unwind if it doesn't work. And none of that was put forward. And that's why we believe there was a change of applicant. And this is an interpretation of law, not a reweighing of the evidence. And we believe on that basis, you've got the ability to reverse and award the CON to Central Florida Regional.
All right. Thank you, sir.
Thank you.
Thank you all.